Okay, start it afresh. That line. Start it again.
Brigadier instructed me to go to Butsilong.
Full stop.
Okay.
Yes. And that one is from your statement. Which statement is for 375? Am I correct?
You correct.
Yebo-ke lokhu okubhalela ukuthi ubrigadier Ndlovu wasengalela ukuthi angihambe ngiye eButsilong kubhalwe kwistatimende sami estatimende leso esimayelana nedokodo eyi-375.
And I can now, without any fear of contradiction, put it to you that Brigadier Ndlovu has deposed an affidavit before his passing on under CAS 375-01-2019. Do you have any response?
No response, my lord.
Ngeshwa-ke anginayo impendulo mayelana nokuthi-ke unestatimende awasenza ngaphambilini kokuthi ashone esiphathelene naleliya dokodo eyi-375.
Your Lordship, I may seek the guidance from the Honorable Court here.
Yes.
Yes. Major General Ndlovu was approached by the investigators of CAS 375-01-2019, the same way the witness was approached to depose an affidavit in 2019, for which he did. When I got the disclosure of 375, the affidavit of Major General Ndlovu was part of that. I just deliberately, yesterday, didn't bring to the attention of the court and the witness what was of primary objective was to deal with the affidavit, Exhibit D, deposed by this witness, having the interest that previously he was of the certain stand insofar as the contamination of the scene was concerned. Having a fear or having the consideration that I don't want to cloud or complicate the issues by introducing this statement or affidavit. And furthermore, at the background of my mind also was that this thing of 2 case dockets for one incident, to me is unprecedented. I wouldn't know how to handle it when I have to bring the application in terms of the provisions of Section 3, Subsection 1 of Law of Evidence Amendment Act of 2008. Because my local standing, Your Lordship, is that I'm the defense counsel for 1 and 4, for 1 to 4. And this affidavit is from one of the dockets that would charge the people who are the witnesses, potential witnesses, not just potential but very important witnesses in this case. So there are potential witnesses under 636, Your Lordship, who may, in turn, change their title. They may become suspects under 375, where there are witnesses of the state under 636, and then they may become opponents of the same entity that they were witnesses before or helping before. So I need to be guided, Your Lordship, as to, can I be in position, if I want to use this statement, to use it to rebut the statement of Mr. Msia? What confuses me, because I don't have that much experience, is that what is my local standing if I have to bring the application in terms of section 3 subsection 1 of the Law of Evidence Amendment Act to say the probative value of this statement is necessary, but now what I'm struggling is that who I am, is it the right position for me? Because I am the opponent of the state, and this is a state witness. That's why I need a guidance, Your Lordship.
Mr. Defu, what you are talking about is something that you want to bring up under cross-examination. But the subject matter of the statement that you now seem to be introducing may have to do with another case. May I repeat myself? Here I am looking at this case. If what you have in hand has a bearing and you want to cross-examine about it, then you pose the question. The other colleagues of yours are here. It will be for them whether they object to the question or they don't. I cannot from my position be seen to be giving you guidance. I give you guidance and they object, and I uphold the objection, and you say this is a strange occurrence. You guided me to do this, and now when they object you side with them. So you are putting me in a very invidious position which we should avoid. If that cross-examination you are busy with in your mind has to entail what you propose to introduce, shoot and see how the target reacts.
What comes out of the bush?
But I can already at this stage point out that the state is going to object to the use of that statement. Firstly, the state is not in possession of that statement, and then secondly, as my learned friend pointed out, this is hearsay evidence. There are specific rules that are laid down in the Hearsay Act. A substantive application will have to be brought for the court to consider. So at this stage, my lord, the state will object to the use of the statement.
Advocate Tefo?
Thank you, Lordship. Yes, I've learned to follow and respect my instincts, as my learned colleague has confirmed me that he was definitely going to object. And I was so cautious, Your Lordship, and I knew where I was putting you, between the rock and the hard surface. So, just because you are a court and you are guiding us here, the parties, I don't want to bleed it further, Your Lordship. I will accept. I think the message has reached where I wanted to reach. That, unlike before, somebody knows that Brigadier Ndlovu deposed the affidavit under 375. If 375 goes further, I believe that this affidavit will be assistant to the state. And I believe that by that time I won't be part of that 375. I think we can proceed, Your Lordship.
Yes, then let's proceed. I should also, because I realize that sometimes when we adjourn, you are in the middle of something. I should alert you to the fact that we have 5 minutes to tea.
Okay.
And we call it tea for convenience. It's many things, but
for sure
we are about to adjourn for tea. So if you are going to another point, be mindful of that, so that I saw that yesterday some of the adjournments were in the midst of a point that is not finalized, and the reality is that there is a specific time for tea, there is a specific time for lunch.
Yes, and I've realized that, Your Lordship, but anyway, I wouldn't bring the complaint to say that, well, I'm on my momentum, it's happened to be broken by the tea or the lunch. But for now, I'm amenable for the tea time.
Yeah, if we do that, then we might have to back earlier instead of. Let me check what time is it now? Oh, I think we still have 15 minutes. I think we can go.
15 minutes?
Yeah.
All right. Thank you. Mr. Msia, I put it to you that for the purpose of this case, 636, Major General Ndlovu was important. His evidence was important. And him, in his person, was important to be there and support his affidavit. What is your answer? Yes, I put it to you.
No comment, my lord.
akukho engakusho ukuthi wayesemqoka kangakanani Major General Ndlovu.
Okay. And the issue of two dockets, Mr. Msia, for your personal experience, for one incident, different theories, different investigators, in your experience of 14 years, or let me say in your whole experience, your 14 years experience as an expert, as a forensic expert, having visited various scenes, and as a police under general. As if now, one entity, being South African Police Service, or the members, that being two teams, on one team on one docket, other team on one docket, different theory. Is this not an unprecedented thing to you? Personally, as you speaking as a police officer.
That's a very strange situation, my lord. I never come across it.
Isimo-ke esinjenayo
Very strange.
la khona-ke ukuthi kuyicala elilodwa kodwa-ke kunamadokoda amabili-ke futhi kunamathimba amabili aphenyayo into nje engakaze ngihlangane nayo.
I agree with you, sir. Even myself, I've never come across this. So, for example, let's talk about 636. As you already know, the theory of 636, and you remember it, about people entering the house.
That's correct.
And while they left, they have left not so good trace. Somebody stayed. Yeah. And the other theory is saying, is opposing the theory of other case docket to say, no, it's nonsensical to say people entered the house and killed someone. You've got experience. You visited many scenes of crime, not scenes of anti-court, scenes of crime. Will I be right to say you have seen a lot in relation to your career, spending 14 years as a forensic expert? You have seen various scenes where people have been shot and all sorts of allegations, the robbery, the shooting of the friend to another friend, or the shooting of the families. Am I correct to say that?
You correct, my lord.
Kweqiniso ukuthi kweminyaka ngiyiphoyisa kuningi engikubonile.
And the late Brigadier Ndofu did explain to you, when you first met him, we explained to you, even though he was not an eyewitness, but he related to you what he has been informed by the eyewitnesses, that there has been alleged robbery, and at the end of that robbery, Senzo Meyiwa has been shot and killed. Am I right? That you got that information, but as a second-hand information.
That's correct, my lord.
Kuyiqiniso ukuthi wamtshela-ke ukuthi-ke bekuzanywa ukuthi kubanjwe inkunzi lana, kodwa-ke obese kwenzeka ukuthi-ke kwasekudutshulwa yena-ke uSenzo Meyiwa.
And you believed that information from your senior, Brigadier Ndofu, by that, Major General Ndofu now?
That's correct, my lord.
Futhi nkathi engitshela-ke ngakholwa ukuthi impela yilokho kwenzeka.
You will never question it. And even today, you don't even question it.
There's no way in which I can question a person who's giving information regarding the incident, my lord.
Angenandlela-ke la ngangabuza khona-ke imibuzo noma ngiphikisane khona-ke nomuntu ongazisayo noma ongichazelayo-ke imininingwane yalokho okwenzeka.
The theory in that 636, that in relation to the incident, two people entered the house, find the people who knew each other, and amongst them there is a famous, a popular, the hero of the nation, and Orlando Pirates, the beloved son of the soil, was with his friend in that house. That house belonged to the family of his
baby mama.